Hi there, I'm Seb Maley, and in this video we'll cover two more IR35 cases which were recently decided at upper tier tribunals. The first involves yet another broadcasting personality and is another case involving Sky Sports, this time the former football player turned pundit Neil McCann. Mr McCann had a long playing career at clubs like Rangers as well as the Scottish national team before retiring in 2011 and making the transition to being a front of camera analyst. He appeared on the BBC, but most of his work was for Sky Sports, covering Scottish football. Like many others, McCann was subject to an IR35 investigation which covered his work with Sky between 2013 and 2018. As I mentioned, this was an upper tier tribunal, which means the case had already been heard at the first tier. For Mr McCann, this was back in October 2021, when the judge agreed with HMRC's view that he was caught by IR35. As we've said many times before, these cases involving broadcasters are highly nuanced and are not particularly indicative of how a typical contractor operates. For McCann, the case hinged largely on the much misunderstood issue of mutuality of obligation. This issue has been a key factor in all of the recent IR35 court cases, and we are currently waiting for the Supreme Court case involving the referee body PGMOL, which should really be the seminal decision on MOO and very much set the precedent for how it should be viewed in future. For me, the confusion and complexity around mutuality of obligation is a stark and obvious sign that the status tests we have to use are not fit for purpose in the modern world of work. It would be incredibly difficult for anyone not well versed in decades worth of case law to get a handle on MOO, and the fact that it changes with every upper tier or Court of Appeal case means there is a huge amount of conflicting information on the internet. Unfortunately for Neil McCann, his hearing came before the Supreme Court case, and HMRC used, perhaps controversially, the precedent set in the PGMOL case decided at the Court of Appeal, even though that decision itself has been appealed. It's been heard, and we are just waiting for the result to be released. Ultimately, the upper tier judges rejected Mr McCann's grounds for appeal and therefore agree with the first tier that his work with Sky was caught by IR35. Whether or not McCann appeals to the Court of Appeal remains to be seen. If he does, by the time it's heard, the landscape could obviously have changed significantly, but clearly the costs and the stress involved may be prohibitive. The second case we'll look at is more relevant for the typical contractor and is another upper tier hearing. This one involves a company called RALC or RALC Consulting Limited, which is run by an IT contractor who, during the period in question, provided services to the Department for Work and Pensions. If the case involving Neil McCann was an illustration of how unfit the status tests are, this case really brings home how painful the process is when having to defend your tax position. The DWP engagement HMRC were challenging started way back in 2010 and ended in 2015. After HMRC challenged the arrangements, the case ended up at a first tier tribunal in 2019, so even that was 5 years ago. Unlike McCann, in the RALC case, the judge agreed with the contractor that he was outside IR35, with the case hinging on our favourite subject of mutuality of obligation, as well as the fact that the judges felt the contractor had control over how he did his work. As they almost always do, HMRC appealed this decision, and so the case was sent to the upper tribunal. Why it took several years for the case to be reheard is unclear, but it finally reached the court in December 2023, with the result being issued on the 12th of April this year. Now, if you thought that was ridiculous, it gets even worse. HMRC had appealed the first tier judgment on several grounds, all relating to the manner in which the first tier judges had reached their conclusions and the process they had used in building up the hypothetical contracts which exist between the contractor and the client. Much of this was based on how cases have been decided in recent years, and incredibly, after the first tier tribunal was heard. Frustratingly, the upper tier judges agreed with HMRC that the first tier had made errors in how they reached their decision and upheld their appeal. Now, in some cases, the upper tribunal can remake the judgment and overturn the original result of the first tier. However, in this case, they didn't, which means that whilst they haven't agreed with HMRC that the contractor is caught by IR35, they have ordered the case to go back to a first-tier tribunal to be heard all over again. This is a ridiculous situation for a number of reasons. A first-tier tribunal is where evidence can be heard by both parties and witnesses can appear and be cross-examined. For RALC, the contract's already ended nearly 10 years ago, and who knows how long it will take for the new hearing to be heard. For the contractor involved, it means even more delays, and if he goes ahead, more legal costs to defend his position. The alternative would be to concede and settle with HMRC, which feels fundamentally wrong when no judge has said that he is caught by the rules. But unfortunately, the process takes its toll, and many will feel like they have been backed into a corner. The case has clear similarities with the ordeal that Kay Adams, the Loose Women TV presenter, went through. The same thing happened with her at an upper tier tribunal, and she doggedly continued her fight and ultimately won again when it was sent back to the first tier. She has been quite open in admitting that the costs involved in defending her case outweighed the potential tax at stake. And when this ends up being the case, you know something isn't right. We'll keep you updated as these two cases develop, so please subscribe to our channel for immediate notifications. Until then, thanks for watching, and we'll see you next time.